The English legal system is a complex system that has evolved over centuries and includes a range of different courts and legal traditions. At its core, the English legal system is based on the common law, which is a system of law that is developed through court decisions rather than through written laws or statutes. The common law is a legal system that originated in England and has spread to many other countries around the world. It is based on the principle of precedent, which means that courts must follow the decisions of higher courts in similar cases. This system allows for flexibility and the ability to adapt to changing circumstances over time. In addition to the common law, the English legal system also includes the principle of equity. Equity is a set of legal principles that were developed to supplement the common law and to provide additional remedies in cases where the strict application of the law would be unfair or unjust. The main difference between common law and equity is that common law is based on the decisions of courts in previous cases, while equity is based on principles of fairness and justice. Common law is primarily concerned with legal rights and obligations, while equity is concerned with the prevention of injustice. Equity is often used to provide remedies in cases where the common law would be inadequate, such as cases involving trusts, property disputes, and breaches of fiduciary duty. Some common equitable remedies include injunctions, specific performance, and rescission. The English legal system is based on the common law and equity. The common law is primarily concerned with legal rights and obligations. Equity is focused on principles of fairness and justice. These systems work together to provide a comprehensive and flexible system of law that is able to adapt to changing circumstances and provide remedies in cases where the strict application of the law would be unjust. In contract law, the general rule is that part payment of a debt does not constitute good consideration for a new contract. This means that if someone owes a debt to another party and offers to pay only a portion of that debt, the creditor cannot then claim that they have given consideration for a new promise from the debtor. The reason for this general rule is that a promise to pay a pre-existing debt is not considered to be good consideration for a new promise, as the debtor is already under a legal obligation to pay the debt. Therefore, if the creditor agrees to a new promise based solely on the debtor's partial payment of the pre-existing debt, the creditor has not received anything new in exchange for their promise, and the new promise is not supported by good consideration. However, there are certain circumstances under which part payment of a debt can constitute good consideration for a new promise. For example, if the debtor agrees to pay a smaller amount in full satisfaction of the debt and the creditor accepts that amount as full payment, this can constitute good consideration for a new promise. Another example is where the part payment is made under a new agreement or understanding between the parties. For instance, if the debtor offers to pay a portion of the debt as a down payment on a new purchase, and the creditor agrees to this arrangement, the partial payment can constitute good consideration for the new contract. In conclusion, the general rule is that part payment of a debt does not constitute good consideration for a new contract.